Thank you, Mr. Chairman. Before addressing today's agenda, I'd like to speak just briefly about the ongoing family separation crisis and the nomination of Brett Kavanaugh to the Supreme Court. On Tuesday, the Trump administration failed to meet the court deadline to reunite all children under the age of 5 with their parents. It's my understanding, I've just read a release that says they will meet that deadline today. I hope so. The government has now admitted in court that parents have been deported without their children. The whereabouts of many parents are unknown because there was no system to track which child belonged to which parent. And at least one case, the separated parent and child may have been United States citizens. It's important to remember that only a small fraction of children in government custody were subject to Tuesday's court order. So the problem of reuniting children with their parents is even more difficult. It's clear that children were taken from their parents with absolutely no plan to reunite them. And that brought untold havoc to the lives of thousands of children and their parents, and we read about it every day in the newspaper. Senators Cruz, Tillis, Senator Durbin, and myself are continuing our discussions. They've been productive, and I hope we can come to an agreement on a bill quickly. What's clearly learned from hundreds of episodes at the border is the administration's immigration policy in handling families and children needs to be changed. I'd also like to address the Supreme Court vacancy and the nomination of Judge Brett Kavanaugh. On Monday night, we all know the president announced his choice for the vacancy. What is unusual is this was just 2 weeks after we learned Justice Kennedy was set to retire. Now, here's why it's unusual. Historically, that process takes at least a month, and at times it has taken several months. What this suggests is that the selection of Judge Kavanaugh was preordained, and the usual vetting which accompanies a nomination perhaps was not done adequately. In fact, it was reported yesterday that Deputy Attorney General Rosenstein sent out an email to all 93 U.S. attorney offices asking that each office provide up to 3 prosecutors to assist with reviewing Judge Kavanaugh's record. Reports indicate the department expects to employ at least 100 full-time lawyers to review over 1 million pages. That's unusual at the very least. This is going to be my 10th Supreme Court hearing, and I have never seen this amount of documentation that will need to be available for review for both sides. While I understand the Justice Department will not be sharing its analysis of the documents, certainly all of what it is reviewing should be made available to both sides for our review. We know that Mr. Kavanaugh served as a Republican political operative working on the Ken Starr investigation and the election recount of Bush v. Gore. He also served as a top official in the White House for 5 years, working in the White House counsel's office and as staff secretary. Judge Kavanaugh was in the White House at a time when the Bush administration considered many controversial policies and made decisions, including warrantless spying, use of signing statements, military tribunals, torture, and the rendition of prisoners to other countries. When Judge Kavanaugh was first nominated to the D.C. Circuit, many of us questioned whether he could be an independent check on the president, given this involvement with the president's use of 750 signing statements to try to reserve the power to decide what laws passed by Congress he would enforce. I'm also concerned about his involvement in the Bush administration's policies on detention and interrogation. Given Kavanaugh's extensive record and questions about his role in the Bush White House, this committee needs to obtain documents from many sources, including the Bush Presidential Library and the National Archives. As has been done previously, I would hope these would be bipartisan requests. Let me give you an example. With Justice Kagan, who also had a background working in the White House, the chair and ranking member of the Judiciary Committee, as well as the Obama White House, joined to make bipartisan requests for an expedited production of all of Justice Kagan's White House documents from the Clinton Library. In fact, the committee received 170,000 pages of documents, including all of Kagan's emails. Nearly all of these documents were made public and available online, and there were no claims of executive privilege. Given this is a lifetime appointment to the most powerful court in our country, the same care and diligence should be performed in securing the information from Judge Kavanaugh's record. All senators, every single one of us, ought to be able to fully and properly review the nominee's record so they are totally informed. Mr. Chairman, I know our staffs have begun discussions, and I look forward to working with you to get this questionnaire out to the nominee, as well as requests for documents out to the Bush Presidential Library, the National Archives, and others. Finally, with respect to Mr. Kavanaugh's nomination, I'd like to quote from a column in this morning's Washington Post, and I believe it eloquently sums up the questions and concerns many of us on this side of the aisle have. This is E.J. Dionne's column, a part of it. Everything we know about Kavanaugh demonstrates that he would cement a right-wing majority on the court on social issues, as well as regulatory and economic questions. Parenthesis, that's why he was picked, end parenthesis. The environment, gun safety, and health care are all at stake. So are civil, voting, and labor rights. Kavanaugh may be as lovely a human being as Garland is, but he would behave very differently as a justice. That's the point. Progressives are told they should get over the shameful treatment of Garland. What an astonishing exercise in hypocrisy from conservatives who have been reliving the defeat of Robert Bork's nomination to the Supreme Court for 31 years. And unlike Garland, Bork got a hearing and a vote. I ask unanimous consent to place the full column in the record, if I may.
Without objection, so ordered.
As to the agenda for today's markup, I would just like to say I very much regret blue slip treatment of Senator Casey. I've spoken with him. He is very concerned. Our side is very concerned. And the fact that we will be voting on Mr. Porter, we all must remember what goes around comes around. And I do not believe it's in the best interests of congeniality or fostering a meaning to a consultative process between the White House and the Senate to ignore home state senators' views and move through nominees against their recommendations. 2 senators on our side have now spoken to me, and both of them are very concerned. Both of them tried to carry out what is supposed to be a senator's part of a consultative process. And now to find that their blue slip isn't respected is very hard indeed. Thank you, Mr. Chairman. I will put the rest of my statement in the record.